excited to see such a robust kind of turnout. I can see some of you joining from different parts of the world. And it's a testament to the growing vital importance of alternative dispute resolution in specialized sectors. And today you'll be hearing a lot. I know some of you will be wondering, what is this geothermal case study these guys want to talk about? Now you're going to hear from the best today. Definitely. Trust me, you're going to hear a lot. Of course, geothermal, I'm not going to tell you what it is or define it, but again, in a simple layman's language, it's where you generate electricity from heat. That's actually what they call geothermal. Now, a dispute arose, from this whole thing. You're going to hear a lot, and it was an arbitration case, and the main man who actually handled the case and won the dispute basically will be telling you a lot about it. Mine is just to kind of welcome you all and just to tell you that today's webinar is kind of a truly collaborative effort. We are incredibly proud to co-organize this session with the prestigious Sari Ibrahimoglu law firm. Partnerships like this allow us to bridge the gap between the academic dispute resolution and the real world high stakes legal practice. And I think this is really important, particularly for young practitioners who are joining us from different parts of the world. You're going to learn a lot from a seasoned practitioner today. Now, we are also deeply honored, I'll say this, to have a true titan of the legal community joining us today. And that's Dr. Salim. I'm sure you can see him on the screen. For those of you who are actually watching us live, he's widely recognized as one of the foremost lawyers in Turkey and the broader region. So where he's not just kind of a Turkish lawyer, he's recognized across the whole region, beyond Turkey itself, Europe, and some other countries. Now you'll hear a lot about his other hats. He wears so many hats. We are really thrilled, to have his brilliant mind in the room today, and I will leave the pleasure of the formal, detailed introduction to our excellent moderator, who is Mr. Mehmet, who is another lawyer, brilliant lawyer, and Dr. Salim. This comes from me. Thank you for being with us today. Really, I appreciate it, despite your very busy schedule. Now, our focus today takes us to the theme for today's webinar, which is behind the award, insights from a geothermal case study. You always read the words, you don't kind of have the insights on what really actually went well, what went wrong, basically the good, the bad, and the ugly behind the award. So this is something you'll be hearing today. And that's why this time around, we just felt we should kind of look at things differently. Let's kind of bring a practitioner, and this will really help you. For those of you who have ongoing cases, or for those of you who are even chairing arbitral tribunal, chairing some panels today, you're going to learn a lot, basically, based on the experience of a seasoned practitioner. Now, as the world transitions towards sustainable energy, of course, you're aware of what is happening in the Hormuz Strait at the moment. So energy security, it's a key issue now for every country. So a lot of projects are springing up relating to alternative source of energy. So as the world transitions gradually towards sustainable energy, geothermal projects have become critical, whether we like it or not. And they are also what? Capital intensive ventures. Of course, when you have a capital intensive venture, then you should always start thinking about disputes. However, with massive innovation and investment comes complexity. And like I said, inevitably disputes. Today, we aren't just looking at the law on paper. We are looking at how a complex geothermal arbitration unfolded in practice, unpacking the strategic decisions that shape the final award. Now, the roadmap for today's session will be given to you by the moderator, but I'm sure you'll be having a case presentation because it's always good to have that high-level kind of case presentation. What happened, how it happened, who were the parties. And after that, you'll be having the fireside chat, with our seasoned practitioner joining us today. And of course, we always give you this final moment to ask questions directly. And I always love that part because it's very interactive. And this is a golden opportunity for you to have a practitioner who has decades. When I say decades, we're talking about maybe more than 4, 5, 6 decades in practice, basically. So you can learn from our practitioner today, and that's why the Q&A session will be very important. And I'm sure you've got the Q&A tab down there. Start asking your questions from the get-go. Now, we encourage all of you to be active participants today, even though it's a webinar. Grab your coffee or tea, whatever you like to drink. Use the Q&A box freely, and let's make this a highly interactive session. And I want to once again thank Sari Ibrahimoglu Law Firm. To our distinguished speakers, thank you again, and to all of you for your continued support of the webinar series of the OIC Arbitration Center. Without further ado, it is my absolute pleasure to hand over the floor, or what they say, the screen, over to our moderator, Mr. Mahmoud, to officially introduce our guest speaker and kick off the session. The floor is yours. Thank you.
Dr. Omar, thank you very much. It's a pleasure to be addressing this esteemed audience today, and under this esteemed umbrella of Organization of Islamic Cooperation Arbitration Center, considering it is an essential pillar in the region for dispute resolution, not only in the region but beyond as well. And we sincerely appreciate its efforts and are closely watching. Myself, to introduce, my name is Mehmet Celal Taylan. I'm the co-director of the Istanbul office of Sari Ibrahimoğlu, and as well as the dispute counsel. I'll be your moderator, your humble moderator today during this session. In order to gain time, I would like to quickly pass over my guests, where I have my colleague, Selena Eylül Sofoğlu, who is the co-director of my Istanbul office as well, and she's a dispute counsel. And on the other hand, we have our speaker of honor, Dr. Selim Sari Ibrahimoğlu, who is the founder of our law firm, of Sari Ibrahimoğlu Law Firm. And as Dr. Omar said, he has many caps in that regard. One of them being him as the Lawyer of Trust of Austria, and was awarded government decorations from the governments of Spain, Brazil, Iceland, and Austria as well for resolving investor-state disputes amicably. And he was recognized by the World Bank for his success in financial matters. And as an addition, I'd like to just briefly explain. He was awarded 3 consecutive tenders by the European Union Tenders and Procurement Departments in a row. And last but not least, he was recognized unanimously by the Turkish Parliament as a trustee, and once as a trustee and an expert in the Turkish banking crisis back in the early 2000s, and in the what's so-called the white energy corruption during the Turkish, again in the early 2000s. So I would like to again welcome my guest speakers. And as per today's webinar, to briefly introduce today's webinar, we will be taken into the heart of a real concluded ICC arbitration, not theoretical but practical, for geothermal plant disputes, a $66 million contract, and a legal strategy that ultimately delivered a result worth nearly $15 million for the client. What makes this case particularly compelling is not just the outcome, but the journey, actually, the procedural creativity, the moments of genuine uncertainty, and the decisions made under pressure that ultimately shaped everything. And we will be listening to these decisions from the first hand. To walk us through the journey, I have introduced my guests, and I would like to leave the floor to my colleague Selena Eylül Sofoğlu, who will be presenting a very short presentation about the substance of the case, where we can have a brief understanding of what the case is and how the practice moved. And then we will move on to our next guest speaker, Dr. Selim Sari Ibrahimoğlu, to answer our humble questions. Again, thank you very much, and floor is yours, Selena.
Thank you for this introduction. I will try and keep this presentation as short as can be. Without further ado, I will share my screen. Is my screen viewable? Okay. So, good afternoon, everyone, and thank you very much for joining today's webinar. As introduced, my name is Selena Eylül Sofoğlu, and together with Dr. Selim Sari Ibrahimoğlu and my colleague Mehmet Celal Taylan, I will be presenting a case study concerning dispute management in energy investments, specifically an ICC arbitration relating to 4 geothermal power plant projects. So, as a first glance, The dispute arose from a contract dated the 11th of April 2013, titled The Contract for the Supply of 4 Geothermal Power Plants. The subject of the contract was a supply of these geothermal plants based on ORC technology, which signifies the organic Rankine cycle technology. Put simply, the ORC systems are commonly used in geothermal energy projects to convert heat into electricity through an organic working fluid. The total contract price was, as you can see, approximately 66,300,000 US dollars, so approximately 64 million US dollars. And under this contract, the supplier, who would become the claimant in the arbitration case, was responsible for the engineering and design and the manufacturing of the main equipment. And the client, which is our client, the investor, would be the respondent, and our client was responsible for complying with the payment schedule and managing the site-related obligations. So here is a general summary. The arbitration concerned disputes arising from the design, the manufacture, and the supply of these geothermal power plants. First, we have to discuss the core of the dispute, which were 2 main issues. The first issue is whether the supplier had properly fulfilled its engineering and delivery obligations under the contract. So this was put into scrutiny. And secondly, in relation to the first point, whether the contractual mechanism known as a cancellation curve, which will be discussed further on, could be relied upon the supplier to claim compensation. Because the claimant's request, as you can see, was 13,500,000 US dollars, and the dispute amount was close to 15 million US dollars as well. And the respondent's counterclaim, which was our client's claim, was 1.2 million US dollars. So when we go to the transition to arbitration, now we are at the stage where the dispute is formalized. Before the arbitration phase began, as per the contract which was stipulated between the parties, the only way the parties could go to arbitration was through the exhaustion of amicable resolution. So here we see, following the CEO level meetings, which were held in September and November, no settlements were reached. So since the exhaustion of amicable resolutions on the CEO level were completed, we could now activate the arbitration clause. And this is the letter which was sent by the suppliers' council, the claimant, that the dispute has ceased to be a matter of commercial bargaining and would be resolved before the ICC. The important point here is that our client's defenses also started turning into formal legal claims as well. At the judicial phase, we see that the arbitration clause, which was Article 4 of the contract, shaped the whole procedural framework of this case. So the clause provided that disputes would first be attempted to be resolved amicably, as discussed in the previous slide, and the seat of arbitration would be Zurich, Switzerland, as is often the case, and the arbitration institution would be the ICC. So before going on to the arbitration phase, the amicable we would like to further explain what happened with the amicable settlement stage, because this wasn't just a procedural formality, it was factually important as well. Now, behind the settlement attempts, there were already serious field problems with the operational issues of Pamukkara 1 and 2 concerning the N-butane losses, as you can see. So these operational issues had already undermined the trust between the parties. And these problems also directly affected the parties' relationship regarding the oncoming Sultan Hisar 2 project as well. The final award also noted that before the Schedule 2 to the agreement, there had been serious disputes between these two sides as well. So, as mentioned before, the first CEO level meeting took place on the 28th of September 2017. And here, the parties tried to resolve the dispute, but no solution was reached. And the second CEO level meeting took place on the 27th of November 2017. Since these meetings did not produce a settlement, they became legally significant as evidence that the pre-arbitration negotiation mechanism had been exhausted. Beginning the arbitration, here we noted the important dates. On the 10th of September 2018, following the exhaustion of the amicable settlement phase, the claimant filed the request for arbitration. And on the 2nd to the 9th, the ICC court proceeded with the appointment of the ICC court arbitrator. And when we come to the 17th of January 2019, which is the final date, the official appointment and the file transmittal was completed, and we now had an official formal arbitrator appointed to the case. We had 5 strategic pillars as respondent in this case. Our first position, which we will explain all of these strategic pillars in the points to come, and Dr. Selim will also mention these in detail. The oral cancellation claim, which was tightly knotted to the June 2014 meeting, which had taken place 3 years before the amicable settlement phase. The second is the cancellation curve. The cancellation curve was addressed because we had to discuss whether this mechanism could legally support the supplier's compensation claim, the scrap status, and mind you, all of these strategic pillars are intertwined. The scrap status concerned the claimant's claim that all of the sites were tailor-made to the client, and hence it had to be scrapped when the contract was null. And the other points are part similarity, and related to all of these points, the letter of credit and advance payment by our client. Our first defense strategy was discrediting the oral cancellation narrative. Now, the supplier argued that the meeting on the 11th of June 2014 was a cancellation meeting. In this meeting, the supplier argued that our client had orally cancelled the contract. And for this reason, the cancellation curve had to be put into place, which we will explain in the future. Now, we argued that this was not correct. The meeting did concern technical problems and maybe possible alterations, but never termination. We also emphasized that the parties' subsequent conduct, the conduct of the supplier, was inconsistent with this cancellation narrative. Because if the cancellation had indeed been cancelled in 2014, then the parties would not have continued these technical discussions and the amendment negotiations. Now, the second major aspect was the technical nature of this dispute. From the outset, we argued that the case could only be properly resolved through technical data and expert evaluation. I will go into this matter in detail as well. The arbitrator at one point rejected our request for technical examination of one of the areas of dispute because the relevant structure was located on a third-party site. We had to pursue local remedies from a local court to appoint a technical examiner and submit those findings into the arbitration file. Now, this was one of our more creative solutions to the case. Our second defense strategy was weakening the claim of scrap status, which I mentioned before, because it was the claimant's narrative that Sultan Hisar II was tailor-made for our client. But as mentioned in the previous slide, we appointed a local court examiner to identify the technical similarities at a third-party site, because the arbitrator had previously rejected our request to send a technical examination group to the third-party site due to that site not being in the it wasn't within the jurisdiction. So we had to come up with our own solution to this case. The findings of this did not only weaken the scrap allegation that the claimant had argued, but it also challenged the broader dimensions of their narrative as well. Because if the equipment could be used or sold elsewhere, then the claimant could not simply argue that it had suffered the full value of the alleged loss. We also argued that the nature of the cancellation curve was under Swiss law. So our position was that the cancellation curve should not be applied mechanically or automatically, but the question was not only whether the clause existed, but whether its application in circumstances could create a disproportionate result or an unjustified economic benefit for the claimant. And this was argued in our position as well. Now, the oral cancellation claim was refuted by us under three main arguments. First, obviously, under Swiss law, any cancellation had to be made clearly and explicitly. This does not mean to say oral cancellation doesn't exist under Swiss law. It does, but if it is made, it has to be irrefutable and it has to be proven by the party arguing that this is the case. Secondly, our witness testimony supported our position because our witnesses rejected the cancellation claim both in writing and during the hearing, and they stuck to it despite the badgering of the other party. And the third point was that the claimant's own conduct contradicted its case. What I mean by this is that one of the claimant's internal emails stated, quote unquote, "We are investing if we can deliver SH2 earlier." Now, this was an important point for us, evidently, because it showed that the contract was not in fact cancelled by the will of the parties. This was mentioned in my previous point as well. We had to regard this oral cancellation claim in regards to Swiss law and our witness testimony against the badgering and the claimant's own conduct as per the SH2 email that I mentioned before. Now, regarding the cancellation curve, the arbitrator's decision was in favor of our strategy because the supplier claimed approximately that 13.35 million US dollars, arguing that this amount was payable automatically and directly according to the curve in the contract, the cancellation curve. Basically, what the cancellation curve entails is this. Both of the parties enter into an agreement, and due to the nature of the agreement, since there will be sites that are based and cannot be scrapped, because it's tailor-made, if the party cancels the contract at any stage, then the other party can go to the canceling party and ask for an amount which will be calculated according to the cancellation curve and ask for compensation accordingly. Ultimately, the arbitrator rejected the supplier's claim in full because the arbitrator concluded that the supplier had not actually proven its loss and that the amount claimed was excessive and therefore against Swiss law. In this manner, we had a few available defenses. Firstly, we argued that the mechanism had the character of general terms and conditions, and it was prepared unilaterally and not individually negotiated. Secondly, we argued that the oral termination claim had not been proven and the contractual relationship had continued. And thirdly, we argued that the cancellation curve, as applied by the supplier and as also applied by the arbitrator as well, operated more like a penalty clause rather than a genuine damages mechanism. Now, regarding the proof of the alleged oral termination, the key point is simple here. We argue that the business relationship was not cancelled at all, but it continued without interruption. In 2015, the other side requested that a letter of credit be opened. Now, if there is a cancellation at hand here, this is inconsistent because the argument here is that the contract had already ended in 2014, and yet there is a request from the other side that a letter of credit be opened. We also see that the technical negotiations continued without any hindrance, and most importantly, the parties later entered into amendment number 2, as you can see here. The third option concerned the legal characterization of the cancellation curve. We argued here that applying the cancellation curve in the way requested by the supplier did not amount to a genuine damages claim. Rather, it had the characteristics of a penalty clause based on a predetermined fixed amount. This was particularly clear because the supplier requested very substantial compensation, but while also accepting that only part of the work had actually been completed. Now, under Article 163, subparagraph 3 of the Swiss Code of Obligations, a judge or a tribunal may reduce an excessive penalty clause at its discretion if it finds the penalty to be too excessive. Now, going back to the cancellation curve, even if the cancellation curve were considered applicable in principle, the amount claimed still had to be assessed in light of these principles: proportionality, actual loss, and the prevention of unjust enrichment. This was a significant point in our arguments as well. And it's very much intertwined with the claimant's allegation of scrap as well, because it was argued, as mentioned before, that the supplier was forced to scrap the whole material for Sultan Hisar II because it was, quote unquote, tailor-made. Now, our strategy at this point was based on our own individual research procedure, because here, one of our Kazakh student interns, which did their student internship at our law firm, did their own research and found that similar equipment was identified on another third-party site, very similar to Sultan Hisar II. Now, this observation became the starting point for further technical investigation, and we did raise this point in our objections in the arbitration as well. We also requested the document showing the scrap value, because even scrap has measurable value. Yet the supplier was unable to provide adequate documentation proving this allegation. So ultimately, the arbitrator found that the claimant had concealed the equipment. They had been used in another project, and this was considered contrary to pacta sunt servanda, i.e. good faith. The duty to mitigate damages was also very central in our argumentation as well. Now, refuting the scrap claim, what we did first was through technical similarity analysis. In our submission, we compared the electricity generation values of Sultan Hisar II to Buharkent, the third-party site, which was based on publicly available information online. And we used the similarity between the two data and submitted it to the court. Later, we emphasized that the scrap claim was raised late because this argument coming from the claimant had not appeared clearly in earlier witness statements or during the document production stage. It was raised mainly at the hearing, which made it look like a new and unsubstantiated allegation. And thirdly, we referred to indirect testimony. The relevant witness, U.J, not giving the name, did not personally witness any scrapping process, but this witness was one of the key witnesses of the claimant side. And despite that, he had not seen the physical scrapping himself and was only informed internally, despite being one of the important positions in the managerial section of the company. Now, his answers to the arbitrator's questions confirmed this indirectness as well. And all of these points together seriously weakened the scrap narrative. This, apart from what the other party did, this action we did ourselves was of great importance as well. We referred to the Nazilli Second Civil Court of Peace to instigate an inspection before the third-party site. The Nazilli Court inspection was one of our more creative legal steps in formulating our defense, because the arbitral tribunal had stated before that it couldn't conduct an expert examination at the third-party site because that site belonged to a third party. It didn't belong to a site concerning the two parties of the case, as mentioned before. Now, to address this, what we did was we used the Turkish local court procedures and obtained a technical inspection through the Nazilli Second Civil Court of Peace. And this court findings introduced concrete technical findings into the record regarding the site that the arbitrator could not access. And we also used these findings to further mount our defense as well. Now here we see that even if the arbitrator rejected certain procedural requests, the inspection did create a doubt in the file despite this rejection. And the idea was, even if the tribunal says, I am rejecting this on procedural grounds, the arbitrator may still think perhaps this equipment really was sold or used elsewhere as argued. This doubt was strategic, and submitting the Nazilli report did carry the risk of procedural rejection, but the strategic gain was that it planted the suspicion of resale. Now, requesting the immediate termination of the process based on the Nazilli report was also likely to be rejected, but it showed good faith on our part because we wanted to resolve the issue and any doubts that were there. And it demonstrated that our side was trying to simplify the case and the dispute here as well. Now I'm coming to the end. The final strategic pillar concerned the letter of credit and the advance payment of our side as well. The supplier had argued that our client's failure to open the letter of credit constituted a material breach of contract, and according to the supplier, this justified the application of the cancellation curve. But our position was based on a principle of exceptio non ad impleti contractus, which is the defense of non-performance. Put in simple terms, a party that has not properly performed its own obligations cannot insist that the other party continue to perform its obligations as if nothing happened. So it's all vice versa. Since there were serious technical defects and operational concerns, our client's refusal to open the letter of credit was in fact legitimate, and it was a contractual response. In the end, the final result was that the the final decision. It confirmed that our client's defense strategy was successful, and when not only the expressed awarded damages, but also the avoided risks are taken into account, you can see here the avoided risk of 13.35 million US dollars. This is the damages of the amount that was sought by the supplier and which was rejected by the arbitrator. 1.32 million US dollars was recovered in cash, which was ordered as a refund of the advance payment. And the total impact of these two values is $14.7 million, the total of the avoided risk and the cash recovery and the cost reimbursements. Thank you very much for listening to me. And now I will stop my screen.
Thank you very much for this presentation. Actually, it's very good to see that what we have done in the past in a professional and overall presentation. And now I'd like to turn the spotlights to Dr. Salim for to reply our questions corresponding to this presentation. Again, Selena, thank you very much. I'm turning to Dr. Salim. I have categorized my questions into certain phases of this hearing, starting with the contract and arbitration clause, which is very essential. It's one of the pre-elements of this process, as we know. The clause, as we have heard from Selena, required a CO level negotiations before arbitration could begin. It's like a preventive measure for the parties to first mediate and somehow find grounds to negotiate before going to arbitration, actually, considering the value of the case. Those meetings happened in September and November in 2017 back then and went nowhere. And in practice, what does it take to satisfy that kind of precondition in a way? And did the claimant try to argue, or what was the claimant's attorney's position in these negotiation phases? If you could reply shortly, please.
Well, I mean, at the end of the day, it's a legal obligation that both parties signed for amicable settlement period. In any case, in the beginning, our client also was very negative that the amicable settlement negotiations shall not bring any fruitful result. But I convinced them that, first of all, regarding the conditions of the contract, they have to do it. And the second thing is, this is my personal idea and strategy. I told them that, first of all, during the amicable settlement negotiations, even if you think that there will be no result, it is very important to understand and to learn what are the real thoughts and what are the real claims of the claimant, because this is very important so that we will be able to know everything beforehand so that we can check whether we have anything to defense against it. So it's a kind of strategy, and it was very useful because at the end of the day, the claimant during this amicable settlement process, they told everything that they have in their mind, And the main argument was the cancellation curve. And we understood that they have nothing in their hand other than cancellation curve, which was the important thing. So it is always very useful to come into the amicable settlement negotiations. First of all, at the end of the day, you are just signing a document that you couldn't agree, but there you are mentioning also quite a lot of ideas that you have in your mind. So for that reason, it is very important to know what the claimant has in his mind and also his claims before the real arbitration stage already starts. This is the most important thing.
So basically, it provides an overview of their ideas. So it's interesting.
Yes. I mean, it was my strategy to get their ideas, even if there is not going to be any amicable settlement.
I see. And it's interesting because in my next question, actually, I was going to ask something about the benefit of implementing Swiss law within the contract. We know that Turkish law of obligations is a reception law, where the Swiss law is translated and adopted with just minor changes. And the Swiss law governed the contract in that dispute. That meant Articles 163 to 377 onwards of the Swiss Code of Obligations become central to the case. And one was the dealing with penalty clauses and the arbitrator's power to reduce the penalty, which we have in the Turkish Code of Obligations as well. And the other was with the cancellation rights. How did you build your Swiss law submissions, considering the other party, and what was the nationality of the counterparty counsel? Did you instruct a Swiss law expert from your own side? And if so, how did you manage the interface between the Swiss law opinion and your own argumentation strategy?
Well, I mean, to apply this Swiss law was a great advantage for us because the other party's lawyer was from Germany, and their law of obligation is not in line with the Swiss law of obligation. So this was a kind of good advantage from our side because to understand and to put everything as a strategy, as a defense strategy, needs to be educated on law of obligation. So for that reason, we had the advantage of that. And the second thing is this cancellation curve is a kind of general condition which was directly conditioned by the claimant, and they put it in front of our client. So this general conditions in Turkey is not accepted by law. And also we checked the ICC precedent decisions and also Swiss court decisions. And according to Swiss court decisions, it is not accepted also, but it's a kind of precedent decision of the Supreme Court of Switzerland, but it has not been accepted as the law. So for that reason, this was great advantage for us. We already studied in that sense, but of course, during this study, it is very important to check the Swiss law of obligation and also the precedent decisions of the ICC, and as well the Swiss Court of Justice. So we had the chance, and this was one of the reason why we could put everything before the arbitrator. Second thing, as Selena explained, their oral statement was not having enough power according to Swiss law obligations, because such kind of cancellation curve should be also cancellation should be also proved in a written form. And despite their claims, we already presented some email communication that's coming from them to us. And in this email communication, it clearly proves that our clients never ever canceled the contract. So there can be
We
no.
will come into those details, Doctor. We will come into those details, but before that, I just wanted to discuss the contract and arbitration clause phase. And I have my last question for that phase, and after that, I'll move on to the substance of the matter. About the language of the hearings, it was in English, and it was
Yes.
and a bilingual contract was determined, but English was prevailing. However, all of the documents were in Turkish. The contracts were in Turkish, the underlying documents were in Turkish, the witnesses were heard in Turkish. And did that create any practical friction? And were there translation or other interpretation issues that actually that affected the substance of the argument? Or was it expensive on the other hand?
Well, actually, this is a kind of nearly, if we calculate the interest, it's about more than $17-18 million. So expenses regarding translation was not a big problem, and every documentation was translated already. And also, the second thing, our advantage was the arbitrator was from Switzerland, so he was able to understand exactly under the Swiss law. So this was a kind of advantage for us, but there was no problem regarding translation, and everything was very clear regarding this issue.
I see. I think choosing the center, the dispute resolution center, the arbitration center is essential as well. Well-built centers in that regard are they provide professional services, I think.
Yes,
And
that's true.
yes, and coming on to the part regarding the term of the hearings, it was actually the main core of the hearing during that time, it was a COVID term where we had the pandemic.
Mhm.
And the arbitrator raised the possibility of a virtual hearing during the COVID. Both sides agreed to go in person. Actually, it was a risk at the end of the day. And was that a strategic decision on your side, or was it more about fundamental, like, how did you make that decision for in-person participation?
Well, at the end of the day, live hearing is always useful because you are able to look at the eyes of each witnesses, and also uh, personal personal beings are always physically much better than virtual, because with virtual many manipulation can be on the picture, but when you are lively there, then you will not be having any kind of artificial help. And we wanted to know the truth, and we believe that truth is on our side.
True, interesting. And my next question will be regarding the help that you had taken from the local Turkish courts during the hearings. It's interesting because the seat of the arbitration is in Switzerland. The arbitration center is ICC. However, you managed to get a report from a local court, Nazilli court, because the arbitrator rejected the request for a technical expert, and you went to the Nazilli Civil Court and obtained an inspection report. In Turkish, we call and how did he introduce that report to the ICC proceedings in the first case? And was it compatible with the Swiss law? Did Swiss law allow such an implementation? And how was the procedure in that, taking a local court decision, local inspection report from a local court in Turkey and presenting it to the ICC hearings?
Well, actually, before explaining that issue, I think I have to go a little bit backwards, when how we started to work on this issue, and I think it is one of the core issues that I will explain you. First of all, when we started this arbitration issue, uh, our client was really hopeless. They were thinking that they will lose this case, because they had no idea about cancellation curve, they had no idea about Swiss law, and additionally, they had the experience that Turkish companies are usually losing in this ICC cases. So for that reason, we needed to be very careful, and because of that reason, I started to check and also talk to all the relevant engineers who had the experience from the beginning, even the ones before. And that was one of the use of that. And I think, I mean, every defense lawyer, I advise them to check all, from the origin, from the source, what happened in the beginning, what are the consequences. So I was very lucky because in the beginning I found one of the ex general managers of this geothermal plant, and he was fired. And I found him because he was the one who started from the beginning. So I wanted to go back to the memory of the plant, and I asked many questions to him, and also I got some hints that the plant, which was going to be completed the Swiss company in a way, and I realized that there are some question marks whether this geothermal plant was really manufactured or produced before, because he told me that this kind of geothermal plant, you order it, at least you have to wait for 1 or 1.5 years. So it takes some time. This was the important information, and I said, okay, if they do not if it is understood that that they did not produce, or if they could not prove that the geothermal plant already one way or the other, they couldn't do the rest of the items and the plant's spare parts. Then what will they say? I mean, at the end, he said to me, "Well, they will say that they will scrap the plant." So under that condition, I said, then when you scrap the plant, then there must be some sort of gold, silver, and some other mineral products out of that. So I was ready from the beginning. So mistakes are never done later. The mistakes are always done in the beginning. So for that reason, we had this knowledge. But what made us to go to the Turkish court was something very interesting, because during that time I was having three Kazakh lawyers, trainee lawyers, but they were the excellent guys. So I asked them to examine it, and when they were examining during internet, they found out that a plan of this company already was done for another Turkish company, a very big Turkish company, because it was very interesting. This Turkish company, which exactly have our plant, in their website, they forget to write down their name, but they write down our client's name in this internet page. So we understood that the plant which was prepared according to our agreement for us was sold out, and also they sold out with the $3 million profit. Our Kazakh student entered this website. They immediately canceled the name. So after knowing this, we asked the arbitrator to determine whether this factor is the same. But he rejected this. I can understand it, because he knows that he doesn't have enough jurisdiction authority in a third country. So under that condition, I asked the local court to make this research. Here, I have to tell you, the arbitrator doesn't need to recognize the determination of the Turkish court, but the point is this: the technical determinations, technical findings that we delivered from the Turkish court, already presented to the arbitrator. Because the arbitrator, even if he says, "Okay, I do not accept this court procedure from Turkey," but at the end of the day, in the report there were some technical arguments which gives an idea to the arbitrator. So arbitrator, especially during the hearings, he asked the technical determinations, especially to the other side, to the climate, in order to answer them and to prove them. So what it means, by using the Turkish court, we use the technical arguments regarding this case,
So
because
the arbitrator deemed it admissible and took it into consideration.
then again, arbitrator, at the end of the day, if he doesn't accept these technical arguments, he has to write down in his decision why he didn't accept these. I mean, it is not the matter of accepting the Turkish court or not, but what we found is the technical claims, technical defense arguments. So these defense arguments were also our defense arguments at the same time. So he had to respond them, and also he asked the other side, the other party, about these issues. So this was something which was very important. Yes, okay, I can continue whenever you ask something.
Thank you very much. And you addressed one of your interns while answering this question. Actually, I was planning to address that part as well, because we know that during the hearings, the other party counsel, which was Clifford Chance attorney, disregarded their young lawyers, and only their senior lawyer was speaking all over the hearings, despite that they had some young lawyers with him as well. But in your office, even the intern, a student intern, was involved in this important arbitration, this crucial arbitration. What does this signify? I mean, is it because could like what happened exactly? How do you work in such arbitration cases and involving such an intern? Does it benefit you in a way?
Well, actually, it's a kind of strategy, and also this strategy maybe it can be very useful for the audiences to understand it during the conference hearings and the preparation of the arbitration, etc. It is also you need to act in a very good strategy and tactic. For example, in one of the conference hearings, the climate raised around 13 or 14 conditions for the procedure of the arbitration. And most probably, he was thinking that I will be objecting at least three or four of those requests. And all of a sudden, I said, yes, I accept everything. So this was a big challenge for the claimant because his strategy was that I was going to object it. But my idea was to finish the case or complete the case as quickly as is possible. And I know that he was expecting some of the claims that he's raising that I will be objecting. I said, no, I agree with all these procedural issues. So the procedure during the procedural conference hearings, the strategy also is very important. Regarding the court issue, uh, well, I mean, unfortunately, the climate lawyer is a senior lawyer, and he had, I think, two or three young women lawyers there, but he was not giving the floor to them. So first of all, this is a wrong strategy to my point of view because you can during whole 3 days we are in a court and we are just have to deal with everything. So because of that reason, I gave the floor to young lawyers, which I really love to make them to educate. Well, I mean, it was a strategy because when the young lawyers were asking, some of them are weird questions, I was able to think, I was able to understand the psychology
And
and
gain
also
time
the
at some
meaning of
point, I think.
the questions. So during that time, the climate lawyer was tired. I mean, so for that reason, I was able to answer these questions, and I was able to think what sort of questions that I can ask during this time. So, and even especially in the second day, when it was about 5-10 minutes to complete the arbitration hearing, the second day, I just addressed to my colleague. I said, "Look, my dear colleague, there are three young and energetic lawyers over there, and you are not giving the floor to them. Although I am the defense lawyer." He was embarrassed, and I looked at the arbitrator and said, "Am I not true?" Arbitrator was a little bit embarrassed. He couldn't say anything. But the next morning, he allowed one of the lady defense lawyer to speak only for 5 minutes, and during the coffee break, she thanked me. I mean, but this is something really tiring. Can you imagine in the Zurich, you are not. I mean, from you are starting from 8 to nearly 7 p.m. and then the whole night you are studying for the next day hearing. So it is not something normal. You will be tired. You know, you cannot put everything into order. So we managed to organize this. So for that reason, it is very important to be ready for all these witnesses, what kind of strategy that they are going to arrange. So these kind of tactics are also very important.
Thank you very much. And I would like to address our audience. Please feel free to write your questions. Meanwhile, we're discussing with Dr. Salim so that we can have your questions and gain time in that regard. I'll be asking your questions. Uh, and I would like to step into the claims, starting with the oral cancellation claim. where the claimant argued the contract was verbally cancelled at a June 2014 meeting. And you argued that it was a negotiation meeting about variations and problems, not a cancellation. So the
Yes.
arbitrator held that a contract of this scale requires clear and written notice of termination rather
Yes.
than just a verbal discussion.
Yes.
So it was a negotiation meeting, and suddenly the other party pops up with such a claim. So as an attorney, as a party as a representative, as an attorney, as a counsel, what should this teach us about the attorney's position in such negotiations? How should the attorney act and speak with the other party to avoid such claims?
Well, I mean, you shouldn't say some weird things. For example, I will tell you just to give some warm blood in this issue. When we were discussing with the Climate's Law Office, which is one of the biggest law office of the world, it was very unfortunate because one of my clients' lawyer, who doesn't speak too much English, and he said, "Look, Mr. Salih Ibrahimoğlu, why are we negotiating? There is no need to settle it amicably because if we go to arbitration, we will issue a lot of invoice to our clients and we will enjoy having this arbitration." So immediately, the senior lawyer changed this guy, the Climate's guy, but I think it is very important to settle these things amicably with the goodwill of the councils. It's also very important because I really wanted to settle this issue with an amicable settlement, because if we could manage this amicable settlement, then the plant was going to be ready during our arbitration, and it will be very productive. So it is not only important. It is not only important that we are earning money, but we must also help the economy for a good generation, good developments.
Thank you very much. And pursuing into the cross-examinations of the witnesses, there is a badgering objection. We're not prone to badgering in Turkish legal system, considering it's a civil law system. And in ICC proceedings as well, there is no formal rule against repetitive questioning in the way common law courts would enforce one. How did you frame that objection? Because the other party counsel was badgering with one of the witnesses. And what were you actually trying to protect? The witness's credibility, the arbitrator's patience, or something else? What was your point in that regard in the objection?
I see. Well, our witness was the general manager of the company, and he was speaking English, but not as accurate as he thinks. So, because of that reason, the climate lawyer understood this, and also he tried to create some questions in a deep English mode, so that he might not, and he was in a position and he didn't really understand the full meaning of it. So he understood it and he started to attack. It was not kind of questioning, but it was some kind of claiming. So this was changing the nature. Because of that reason, I had to interfere, because the ego of our general manager, because he didn't want to be embarrassed in a way, but his English, I mean, his technical English was really okay, but the illegal interpretation of these issues was not so good. That was one of the reasons. And also additionally, this general manager was objecting me, saying that Turkish court determination has no use, and ICC arbitrator will never take it into consideration. And I mean, fortunately, the arbitrator was more interested with the technical findings and technical defense mechanism, which we presented by the Turkish court. These were the important things, you know.
So
And
in a way
also,
so in a way we learn how to control the client, because you
yes,
said, yeah.
yes. Well, I mean, this was one of the reasons, and also one day before, his psychology was not so good, as I told you. This is not the floor now, but Because of that reason, he understood and started to attack. Okay.
So stepping into the next claim regarding the cancellation curve, which is essential in energy projects and such huge projects and such claims. So the cancellation curve claimed that $13.35 million based on 30% completion. You ran into two arguments. The first was that it was an unilaterally drafted standard term, as we have standard terms in Turkish
Yes.
civil in Turkish law of obligations as well. And that standard term was never genuinely negotiated. This was your first claim. And your second claim was that even if it is valid, it was an excessive penalty clause, reducible under Articles 163 of the Civis Code of Obligations. These are logically compatible, yes, because they address on reducing the amount. However, rhetorically, there is a tension. As an attorney, while putting it, considering that your clients are present in the hearing room as well, while putting it, uh, how do you trim it? How do you put it in a way not to contradict within yourself and to give a good picture to your clients? How did you present it both to the arbitrator and to your clients?
Well, first of all, as I explained you in the beginning, cancellation curve is a general condition, and in Swiss law, Swiss Supreme Court already issued a precedent decision that these kind of general conditions, cancellation curve conditions, are not valid. Already we had such a precedent decision. As I explained you, this is by law is not accepted by Turkey. And at the end of the day, this was not the only thing, but our client never negotiated this, and they did not understand what it really means. Another important thing is that we presented some email communications, which the claimant really accepting that there is no cancellation. So the email communication between each other proved that. So we didn't depend only on this precedent decision, but also at the same time, all of these factors was presented over there.
So that article, which regulates the reduction, gives the discretion to reduce, as the wording of the article says, excessiveness. The threshold for excessiveness has to be anchored in something concrete, like you have to present, or do you have to present
Yes.
something to the arbitrator to justify the reduction? And
Well,
if so, how did you make the market comparison? Because the project is in Turkey, but you're in Switzerland, and how did you make sure to get some reputable numbers to the arbitrator, and how did you convince the arbitrator with a proportional analysis?
Well, actually, as a defense counsel, you have to think every condition. So under the condition that we could not convince the arbitrators regarding the cancellation curve is not valid, then we had to use another instrument, and it is also very clear in Turkish law and in Swiss law of obligation that you cannot ask more than your damage. So this is one of the issues. So for that reason, we had to bring, in any case, the second alternative over there, and it is also accepted by the Swiss law, because they complete around 30%, and then they are asking for the whole plant in a way. So
Understood.
it was not justified, and also the Swiss law and Turkish law also depends on goodwill and justification. It should be just and fair. So under that condition, arbitrators or judges can always decrease the amount by themselves, by appreciating the situation. So this was a kind of, because at the end of the day, till the day that they claim scrap the plant, we didn't know it that they were going to have this claim. So for that reason, we have to act for any possibility. I mean, we have to come.
So I'd like to step into the scrap allegation. The claimant's general manager during the hearing testified that the parts were scrapped. But it emerged under the arbitrator's questioning that he hadn't seen it himself and was relying on internal information from his company. That's a credibility problem. When the arbitrator's own questions are doing your cross-examination, which means when the arbitrator's questions and the answers given by the other party are benefiting your point, how do you react? What do you do? Do you just let it run, or do you interfere, or do you re-enter the questioning yourself?
Well, I mean, I provocated especially the arbitrator to ask these questions, but they had a very interesting strategy because they raised this swap issue uh, towards the end of the hearings, because it was very clear that they couldn't prove anything according to their claim, and the technical issues was very clear, and also the Turkish court determination was also proving that they already did it. You know why? Because first of all, this the main reason was this: in order to install a geothermal plant, you need at least 1.5 years. So how it can be done to the other Turkish geothermal company, how it can be done in such a short term? So it was very clear. I mean, biologically, it was very clear that our plant was installed to the other one, and they got $3 million more than ours. So this was one thing, but they waited especially for us to catch us at the weak point. So whenever they raised the scope issue, I was ready. I was ready for this result from the beginning, from the very beginning. So I asked directly, dear arbitrator, what if they scrapped? Well, where is their scrapping? Reports of their company, and also when they scrap, of course, there must be some gold, some silver, some copper, and all these things. And they are, according to my calculation, it is not less than $2.5 million, mainly. So the arbitrator understood what I'm trying to say, and he started to ask these questions. And also we asked the questions, but there is one thing maybe you are prepared, but you may not be asking. So before forget, I think it is better if I tell you. In the beginning, as I told you, we accepted around 14 claims and 14 proposals of this climate law office. Well, one of them was the court clerk. So court clerk, it was very interesting because
Actually,
before
my
the,
next question was
yes,
concerning the
yes,
court
my
reporter's
yes,
position,
yes,
because
yes.
we know that the court there was an issue during the hearing with the court reporter's computer in the mid-hearing. What happened, if you can just explain it
Well,
in
what
short?
exactly happened? The court clerk, to my point of view, and the climate understood that they are going to lose it, and since this law office is one of the biggest in the world, and also the climate company was one of the biggest also. So in order to not, they didn't want to lose their reputation. I can understand it, but the clerk says that the court documentation item in her hand, or his hand, fell down from the fourth floor of the elevator. I mean, in order to, you cannot normally drop the item over there because it is very tiny, and nearly the elevator's way of going down by accident is very difficult. So whenever we understood it, immediately our general manager is a clever guy, and I told him to take measures. They immediately called the local police, and he waited at the elevator. He stopped the elevator, and also we found out, and luckily the text of the hearings were safely restored, and everything went accordingly. This was one of the important points, that you have to be very careful, especially when you are having a dispute with really worldwide big companies. And here, you're right when asking these questions. If we didn't prove many things with various evidences, and also with various predecessant decisions, etc., we wouldn't be winning. This is for sure, because you have to use every instrument in that. So that's the reason. In the end, they were a little bit shocked whenever they said we scrapped it, and I said, "Where are the scrap report?" Finished.
Actually, my next question, as we're close to the closure, my apologies for interrupting, but we have 5 minutes. So I would like to come to my closing question regarding precedent decision, as you said. Recently, actually in March, the UK Supreme Court ruled this year that states cannot hide behind sovereign immunity. Considering your position as in representing states, and you were awarded from the states of Spain, Austria, Iceland, and Brazil in that regard. So the court ruled that the states cannot hide behind sovereign immunity to block recognition of awards, especially ICSID awards, it said, because by ratifying the ICSID convention, they already agreed to it. Your case was ICC. But in practice, when your counterparty is a state entity or state-owned company, how does the enforcement calculation work? Which jurisdictions, which assets, and which legal framework gives you the best real chance of collecting, considering you collected assets in offshore jurisdictions during your position as a trustee appointed by the Turkish government?
Well, actually, there is one good example about your question. And one of the ex-Russian guys, he filed a lawsuit before Den Haag court. And as far as I know, he won the case, $50 billion. And also Russia appealed, and I think appealed already approved. So now with this verdict, this guy can easily execute this verdict in the countries which will accept this execution. This means Russian planes or some other properties and that kind of things. But again, it's important in that respect. It depends on the country whether they will use their immunity or not. However, regarding these kind of investments, the main solution is political risk insurance. As far as I know, if the company has a kind of insurance profile more than $25 million, then political risk insurance can work. And this happened for example, in Turkmenistan, when they were having problems to collect their monies. I told the Turkish companies and the professors that you can have political risk insurance, but nobody was aware of that. And this is our worldwide practice, that we solved many problems all over the world regarding international insurance risk policies or insurance policies. This is also.
I think we need a whole separate webinar for discussing this, because it's
Yes,
a detailed topic. I would like to take the last question that came from our audience, which says that can the clerk or tech firm, in our former question, we spoke about the clerk's position. Can the clerk or the tech firm be held personally liable in such circumstances? This is one of the questions asked by the audience.
Personally liable, but it will not solve my problem. Why should I will be losing time to ask the liability of the clerk. Poor guy. At the end of the day, she's not doing it by herself. Most probably, their bosses will pay for that. But it was not also our main problem, because I want my aim was to solve the problem. That's the reason we took the measures. So what I am saying, you must be ready if you are dealing with any arbitration as an arbitrator or the council. You must be ready with all the consequences and new developments. Here, I think, Omar Bey, it is very important this morning's meeting that we have this arbitration in your arbitration center, because usually European arbitration centers are working more on the European companies, so you have less chance in that. And once upon a time, the French Parliament Speaker addressing ICC Congress, and he said that, look, if you are a strong and big company, you are winning these cases. This is not good, and this is not fair and just treatment, because arbitrators getting their money from the big companies, so they are never giving anything against each other. This is one thing. So, and also I have another discussion with this ICC, because in one of our case, the arbitrator decided on a technical matter without getting any technical expertise report. So I'm fighting with ICC. Still, we are fighting and arguing with them. Also in the General Assembly meetings. So all these things, I think, are the advantages of this your organization. So at the end of the day, as a family, we will be able to solve the problems, and nobody can say that you are taking a party or not, especially such kind of stupid things, throwing the court documents from the fourth floor of the elevator will never happen. I mean, at the end of the day. So, everything has to be thought about it, and I think these issues can give a good chance for your arbitration center, to my point of view. And well, I mean, this is all what I can say now. If there is any question, I mean, I'm ready to answer it.
So we don't have more questions. I would like to thank everyone for listening. And Doctor, thank you very much for your time. Dr. Salim and Selina, thank you very much for the presentation. I would like to leave the ground to Dr. Omar Hosseini for the closure. Thank you very much.
Thank you very much. I'd like to really thank the moderator, Selina Hanem, and of course, our distinguished guest, Dr. Salim. We do have a question from Dr. Hakan Berolgu, who just sent a question in after we were closing. And I think he's asking, I don't know whether we can take that quickly. He's saying, Dr. Salim, in your experience, do companies in emerging markets usually start thinking about arbitration strategy only after disputes begin? That's one. He now said, in your opinion, what was the single most decisive procedural or strategic factor that changed the direction of the case? But this question just came in while we're closing, so I will like to use my discretion here to allow you to answer this in 2 minutes, if possible.
Okay, Omar Bey, first of all, thank you very much for giving me this opportunity. Second thing, I think the question is really right, because if you want to avoid these problems, the company must have a very good claim expert. Claim expert means a lawyer and also an engineer who is really capable of that. So we were using a mechanical engineer who already established a power plant and one hydropower plant. So we always use it. So if you have these two claim experts, then you will never have any dispute or any problem, because you will be avoiding everything in the beginning. And according to my philosophy, mistakes are never done later, but mistakes are done in the beginning. So this is a whole strategy. I mean, for example, the amicable settlement could be cut very shortly, but I didn't allow them because I wanted to understand what the devil side, I mean, the climate side has in their mind, so that I will be able to use it. So this is very important. If you don't know your climate and what are the ideas, you can never prepare your strategy. Second thing, also, whenever I handle a case, first of all, I look at the case whether there is anything right, legal right, moral right, then if it is legal right, moral right, it means that you must win the case. So for that reason, you must make a deep research, and you must organize the strategy in a very clever and intelligent way, including the conference hearings, the strategy of when you are presenting the responses and also counter responses, and also your witnesses. So this is a kind of teamwork, and you
Yeah.
must work with the in-house counsels and also in-house technical people very closely. And this is a kind of win-win case in a way.
Yes, because actually I would like to just make an addition because Doctor, please approve. In general, in companies, we see the in-house legal team disregarding the in-house technical experts sometimes.
Yeah.
So it's critical in that regard. So thank
Yeah.
you very much, everyone, for your participation. And Dr. Selim, thank you very much for answering the questions generously. And
Yeah.
Selena, thank you for the presentation. And Dr. Omar, the stage is yours for the closure. Thank you very much.
Thank you. Just one last point, and I think this message is directed there, Dr. Salim, and there is just a compliment from Dr. Hakan Beroglu, who says he's glad to see you again, and that both of you used to occasionally discuss geothermal energy projects during his time as CEO of Maspo Energy. So he's thanking you again. He's also part of this webinar, and he's the one who asked the last two questions. Now, I would like to thank you all, the audience, the panelists, and for me, I have learned a lot from the presentation from Selena, her name, and of course, the discussion, the fireside discussion we had between Mehmet and Dr. Salim. And my five major takeaways, particularly for those who did not join us early, my five major takeaways from this case study offer highly valuable insights for any arbitration practitioner. Even if you're sitting as a tribunal chair, basically, if you are the president of the tribunal or even a co-arbitrator, or even you're representing a client, particularly if you're counsel. Now, the first pillar, actually, the first point I like to say relates to the five-pillar defense strategy, which was shared earlier. I love that, in terms of the way they prepare the strategy from the get-go. Structuring the defense around five core pillars is a brilliant, highly emulable approach. And I think it effectively actually guides the arbitral tribunal through your case theory, facilitating a deeper understanding and significantly increasing the persuasiveness of your arguments. This is key from the very beginning. You need to be able to build your case theory in a way that will actually be very clear and understandable. So this is one thing I learned from the case study presented earlier, the five-pillar defense strategy, and presenting them in a very clear and concise manner. The second point I'd like to point out is leveraging local costs for alternative remedies. In highly technical disputes such as this geothermal project, where a tribunal kind of rejects, a request or application for an independent site examination, the next thing was what they did was they had to approach a local court to secure a technical report. This is an excellent workaround, and I love it, basically. So this is a good approach in terms of strategy for those of you who are handling ongoing disputes. The vital lesson here is to always explore alternative procedural avenues, even after receiving an adverse ruling from the tribunal. Now, the third takeaway for me, I don't know for you, because I was taking notes and listening very carefully like a student of law. The third one is what? Planting strategic seeds of doubt. Now, submitting what I will call a nail report into the whole hearing, that's a nail report, effectively injected a lingering element of doubt into the record. So even if such evidence does not ultimately dictate the tribunal's final decision, it creates one thing, critical friction against the opposing party's claims. And a robust case strategy should always cover all angles to undermine, the adversary's narrative. And this is really brilliant. And this is what we saw in the case study. Now, the fourth one, before I go to the last, is this: relentless fact-checking and accountability. And I think Dr. Selim made this point quite clearly earlier. A crucial lesson for any advocate is the importance of using every available tool to challenge discrepancies, no matter how minor. or bureaucratic they seem. The instance where a court clerk, like we heard earlier, claimed that part of the record was missing, whether it fell down an elevator or it was thrown out of the window or whatever happened, that could have derailed key evidence. So successfully challenging this by involving the police to locate the document was an extraordinary example of tactical persistence. So every counsel must learn that case strategy does not just stop at legal arguments. It requires aggressively safeguarding the integrity of the record of the proceedings. Now, finally, my fifth takeaway, which is the last for today, it's empowering the next generation practitioners. Senior partners should actively resist the tendency to dominate the entire proceedings. Instead, they should intentionally delegate speaking opportunities to the junior lawyers accompanying them. Granting younger practitioners a voice before the tribunal is not only vital for their professional growth, but it is also a fundamental responsibility in grooming the next generation of skilled arbitration advocates. So I would like to once again thank Dr. Salim and his entire team, and of course you, the audience, for your time today. Thank you for making today's webinar a worthwhile session. And I really look forward to seeing you again in June, basically, for our next webinar. And take care, everybody. See you soon.
See you. Thank you. Thank you very much.
Bye-bye.
Thank you very much. Bye-bye.